So, Carolina and Ignacio, I want to return to one of the topics that we touched on at the beginning, which was M&A transactional activity in Argentina, or in which Argentine companies are involved. ZBV is one of the premier firms in Argentina that's frequently involved in high-profile M&A transactions. So I think you guys have a unique position to reflect on where things stand today. So I want to ask a question on M&A transactions again. Carolina, you mentioned earlier that you have seen an evolution over time in terms of, what role compliance questions play in the due diligence process. And that's been around for a decade, but that there has been an evolution over time. And I'm interested to get your perspective in terms of, how do you see the situation today? Are compliance issues within the context of due diligence still considered sort of something that's left till the end of the process, and in the couple of days prior to signing, all of a sudden people realize we need to focus on compliance issues? In other words, is it still kind of an afterthought? Has it taken on greater prominence earlier in the process? And then I'm also interested on a post-closing basis to get your perspective on how relevant or focused are companies that are the acquirers in trying to understand the risks on a post-closing basis.
We have to differentiate also two things. If we're talking about something that is publicly known, sometimes your client, if you're representing the acquirer and you're talking, and this interesting target, but there are, publicly known compliance issues or non-compliance issues or issues, you deal with those separately. I think that, as in every other case, there are separate conversations. Sometimes, unfortunately, not all of the legal team is involved. If there are I'm being super honest here, if there are these publicly known issues, they are dealt in a different way than a normal M&A deal. Sometimes those issues are also deal breakers. You never know. But those are like separate conversations, and in general are being separately handled. You send the due diligence request, and then you see how you deal with these issues until you understand them. Until the trusted advisor understands what's going on there. If we're talking about a more less high profile deal, you send out your due diligence request list. For your client, it's not that important, of course. In general terms, it is important, but it's as important as other issues. Unfortunately, right now, labor issues, social security issues, other issues are being paid more attention than compliance issues, because as we were discussing, no one understands really the impact of a compliance issues. But if as lawyers we end up letting everybody understand that the contingencies of compliance issues as important as social security issues or labor issues or tax issues, then I think we will win the battle. I have to say that as a standard, you'll see the provision. It's not that we do not include the provision. This standard is met. Whether or not it will be a problem in the future, you'll see that in every SPA, even under Argentine law, we always cover it's part of the section on reps and warranties.